Good evening, everyone. I'm Ellie Breakwell, the APM Branches Coordinator. Thank you for joining us today at this APM Thames Valley Branch webinar. Please be aware this webinar is being recorded and you're in listen-only mode. There'll be some interactive elements to today's webinar, so please have your phone or another web browser ready to go and go to menti.com and use the code 64631911. This will also be displayed on the screen with each question. Today we're joined by Richard Patterson. If you have any questions for Richard, you can submit these via your control panel and I will butt in as we go through the webinar and read these out to Richard so you can get your answers as we go. Thank you for joining us today, and without further ado, it gives me great pleasure to hand over to you, Richard.
Okay, well, I'll share my webcam. I think we're going to go through some of these Mentimeter questions first. So just to get a feel for where you're coming in from, always good to see the outlier there, I think could be Hong Kong, which is great. And there's a couple more questions just to see who in the room, how much experience we've got of the PSC and the professional services contract. But first off, which sector? Just give us a one-line answer here if you're on the Mentimeter thing. It's just out of interest to see where we are. Most of you, I'm going to guess, are going to be in construction of some sort. Some of you are giving me a little bit more detail. That's good. That's the normal range of people that we get on sessions like this. No surprises. Move on. So, simple question, client, consultant, contractor, subcontractor. Who are you with? Good to see some clients on the call because it's the clients obviously that choose which contract we're actually going to use. And contractors ought to be here because you should be using the PSC for some of your consultants working for you. Maybe. We shall see. I've got 51 on the call. I've got 10, 17, 22, 23. So it's 50% of you I've got the techie skills to do the Mentimeter. Never mind. Move on. So the big professional services contract, heard of it, used it, give training on it. I'm going to guess most of you are going to be in the middle. Quite a few just heard of it. Assuming just heard of it means you haven't used it. That's one or the other. I'm sort of going from left to right in terms of levels of competence. That's the big one. That's the professional services contract, which is, like I say, the big one. But the session today is on the short version, so that's good enough. Move on, please, Ellie. Next. And the little one, the little short contract. Are you actually using the little one? I'm going to guess this is going to be more, I've heard of it, and probably significantly less actually used it, and that's why we're here tonight. Okay, brilliant. Let's go. Give me the power, Ellie, and I will do my bit. You give me the power. Okay, so that's what we're on about today. We've got a short period of time. Trying to get through this in the time we got is going to be a bit of a challenge for me, but I will give it a go. Okay, so short contract, PSSC. First, quick intro from me. I work for Mott MacDonald. I'm a NEC and procurement specialist, is what it says on my my business card. I've been with Mott MacDonald forever and been working with NEC for quite a while. And I specialise in NEC and I lead on all things NEC in the Mott MacDonald. We have to put that in because we're going to send the slides out to you afterwards. It is only a training course. It's clearly not legal advice. As Ellie's already said, please do put questions in the chat and we'll try and get to them as we go through. To nothing else, it just breaks up the monotony of me preaching about the NEC. Okay, as a starter, just so you're aware, APM is actually strongly a part of the professional services short contract. Your contracts and procurement special interest group, particularly a guy called John Broom, was heavily involved in helping NEC draft the professional services short contract way back in 2013, from which the NEC 4 version has now developed, which was issued in 2017. So a client may employ a consultant under this contract, and they could employ them as a designer, and that could be the owner, the ultimate owner, or a contractor can employ a designer. If you are running an ECC construction contract, you will need a supervisor, you will need a project manager. You could use the professional services short contract to employ the individual to do that role, or absolutely anything else. This contract can be used for any professional service that you want. So we can employ a lawyer, we can employ a financial advisor, whatever you like. we can do it under the NEC Professional Services Short Contract, not limited to construction. Those of you that know NEC will know that this contract is part of the suite, the NEC family, and those of you that know will know that NEC is different. Drafted for clarity and brevity, flexibility, and to stimulate good management. Those are the buzzwords for NEC. And believe me, it is unlike any other consultancy contract that you will come across. That said, within it, you'll see fairly standard provisions for NEC stuff, compensation events, early warning, most obvious ones. But as you'll see, the professional services short contract is very light on program. So it's new. There are risks, but there are definitely benefits and opportunities for both sides. And I do a lot of work with NEC. I spend a lot of time helping Mott MacDonald people with their PSC. That's the main big professional services contract. And the PSC quite often is just too big and too heavy. And I think clients should be looking to think about using this short contract a lot more frequently. So one pretty picture. If you're the client, you're going to need all these people to do stuff for you. And the orange, because that's the colour of the PSC and the PSSC, those are the professional services. These are professionals that you want to employ to give you a professional service. And you could use the big PSC or the little one. Likewise, when you employ a contractor, you'll need the engineering construction contract and so on. To start the whole thing off, I'm going to tell you all the answers. What's the difference between the big one and the little one? The little one, guess what? It's simpler. It's designed and stated to be designed for simple, low-risk contracts. We don't have any options like we do in the PSC. It's almost in one document. We'll talk about that later. There's no service manager. It's just the client and the consultant. There's no intermediary managing the contract for you. And as we'll see, the payment mechanism is a wonderfully flexible mix of lump sums, quantities, and also work on a time charge basis. Very, very limited requirements for program unless you ask for it in the bespoke document called the scope. The scope is something that the client has to prepare to tell the consultant what they want doing. The compensation event process, those of you know the big NEC contract, the process is very, very simple, similar, but simpler. The points there, when the consultant says, I think it's a compensation event, in the PSC, there's a first stage where we just check the agreement that it is a compensation event, and then only after that do we come with a quotation. In the short contract, we give the quotation straight away. Unlike the big contract, either client or consultant can state assumptions. There's no option to ask for a revised quotation. When you get a quotation in, as you'll see in a minute, you either accept it or you tell the contractor what your answer is. There's no process for going round and round in circles getting revisions, so talk to each other. And if the client doesn't respond in time, bit of a shock for the client here, the quotation is treated as accepted. So that's a very high-level summary page. You'll be glad to know I'm going to give you a lot more detail. So the presentation is in two parts. I'll check my time and see how I'm getting on. The first part is about what's in the contract. The second part is about managing it. Obviously, we'll start with what's in it. And in doing that, I'll start with the conditions of contract and then the other tender documents. It's only 15 pages. You can read this thing cover to cover in probably 10 minutes. There's no options, as I mentioned. There's no primary options, main options, secondary options. They're just one contract. Having said there's no options, one of the PSC options is delay damages, and NEC chose to include delay damages within this contract, within the main conditions of contract. We've mentioned the flexibility regarding payments, and obviously if you are asking for a lump sum or priced quantities from your consultant, you've got to make sure that the scope is very clear so the consultant knows what they've got to do and therefore they can price it. Again, that's just blindingly obvious, I would hope. The last line of a document called the client's contract data says, the conditions of contract are, and they bring in the NEC standard document by reference. The NEC standard document is this one. There we go. Look, this is the professional services contract. It's there in all its glory. And the contract data brings in the words of this contract by reference. We'll look at the contract a little bit more later. But then it says, and the following additional conditions. And this is where the client, having chosen the NEC, having said we'll just use this nice little contract, they can go in and add a whole load of extra stuff to confuse everybody if they really want to. I'm suggesting that you shouldn't do, but you can if you want to. If you do put in additional conditions, you've got to make sure they fit with the language and the structure of the professional services contract as it stands. If you know your NEC, there's always an obvious place to make any change because the NEC is so wonderfully structured. And if you want to bring in provisions from the big contract, you could do, but don't get carried away. If you start thinking you need to bring in a lot of different things from the big professional services contract, you probably should have been using the big professional services contract in the first place. Having said that, it is worth a quick look through the professional services contract secondary options to see whether you think any of those are essential for your contract. And if you need to, with a little bit of knowledge of NEC, you can bring them in as additional conditions. And that was the conditions. But we've also got other tender documents, and I like this picture. The client comes up with what's called the client's contract data. That points to the conditions of contract. And it also, actually, I lied to you. I shouldn't be lying to you. That's just not good. It doesn't point to these documents. It points to the conditions of contract, but oddly, it doesn't point to the scope. The scope is in the contract because it's just there. Only the conditions of contract is directly incorporated by reference. The consultant's contract data has a whole load of data, but the document that it points to, that it has in it, the document that it should refer to, sorry, I'm tripping up here, there's also a document called the price list. That's where we get the prices from the consultant, and it's just in the contract. Obviously, these documents require things to be stated in them, more of which coming in the presentation. There's then a part of the document, is just a one-pager called Consultants Offer Clients Acceptance. And the idea with NEC, when it was first published, in theory, if you bought a hard copy of the document, you could actually write everything in and just sign the offer and sign the acceptance, and then it's done. Lovely, but hang on, guys, it doesn't work like that in the real world. We do things electronically, of course. So it won't happen quite like that. And this is the stuff I put in red here is a little bit of a warning about this contract. I think it's a good idea in the contract data to add a clear reference to the scope. In the consultant's contract data, I would add a clear reference to the price list. Just say the price list is blank box, and then we can put a reference to the document where it is. Also, some clients might want a very short form of agreement to formalize the agreement of the contract. Again, you don't need it if you've used this offer and acceptance form.
Hi, Richard. Just one quick question.
Please.
Ahmed has asked, does it include payment conditions or project milestones?
Payment conditions, yes, we'll talk about them. Project milestones, no, except there is one date when the consultant is required to get everything finished. That's the nearest we get to a milestone. Good question. Keep the questions coming because you will all learn much more from questions. The only silly question is the one that you don't ask. Okay, so please keep them coming. So the other tender documents, we've got a document called scope. And exactly the same words as in all NEC contracts, it's information which either specifies and describes the service, that's what we want, is a service, or states any constraints on how the consultant provides the service. And is either in the document called scope or in an instruction given by the client to the consultant to change the scope. Pretty obvious, pretty simple language. NEC is lovely with its simple language. Some of you will remember Ronseal. It does what it says on the tin. And the scope is the same. If you don't put it in the scope, the consultant hasn't got to do it. If you don't mention a constraint in the scope and then you want to add one in later, it's going to cost you money, extra money, because that will need to be a compensation event. And the first compensation event in the contract is the client gives an instruction changing the scope. There's also a mechanism about accepting defects, but that's probably a little bit too much detail for today. And also, like in the big contract, there's a clause which makes it very clear that if the client changes the scope to correct an ambiguity in the scope, the consultant wins. The consultant gets the benefit of any such ambiguity, which is fair because you're supposed to write the scope. It's your job to make it clear. And if it's not on the tin, in other words, if it's not in the scope, be aware, oh clients out there, the consultant doesn't have to do it. Very, very simple. In the contract, there are various references from the conditions to the scope. We've talked about that one. Also, it says the client provides information and other things by the date stated in the scope. So this is like the NEC, the drafters of the NEC trying to prompt the client to write a decent scope. What are you going to give to the consultant? We need to know. When are you going to give it? We need to know. It needs to be stated in the scope. Also, you only have to provide programs as stated in the scope. Also, there's some reference to things to do with intellectual property rights. The client has the right to use material provided by the consultant for the purpose stated in the scope. So if you're a consultant, you need to check that. You need to make sure that you're happy with how much you're giving away the rights to your material. And the other way round, the consultant may use the material for other work unless stated in the scope. In other words, if you do some good stuff, you can carry on and use that on your next job. And that's obviously what the consultant is going to want. And the consultant is going to look very carefully and very unhappily if the client tries to stop that in the scope. The point here is really quite important. So your clients and your lawyers are always worried about intellectual property rights. In this case, with the NEC, you've got to make sure that's been set out clearly in the scope document, which remember is a bespoke contract-specific document drafted by the client. Now, in the document, in the contract itself, let me show you, in the contract itself, I did put my bookmarks on just before I came on, which is a really good idea. In the document itself, it gives a guidance and a potential structure for the scope document. So can you see the idea was, if you wanted to, you could just write it in here, just write it straight in the document. In the real world, that's not going to happen. We don't do contracts like that. But what I've got on my slide here is what the NEC is giving you as a guidance on what you need to say in the scope document. Those entries are purpose of the service, description, information, standards, constraints, program, and so on. And a warning for you, if you're using just that document, this is a mistake in the contract. I've fed this back to NEC. That guidance document doesn't include here the required entries regarding rights of material, which I showed you on the previous slide. Small detail. Contract data. It's just a form. You've got to fill it in. You've got to fill in what's the starting date, what is the service, and so on. It's only 3 pages, the client's one. It's only 1 page, the consultant's one. As I mentioned earlier, I think it's a little bit odd that it doesn't directly point to the scope. If I was advising you as a Mott MacDonald advising a client, I would advise you to add in an extra entry into the contract data. The scope is. Point it to where that document is. The price list. Somebody asked about the pricing mechanism. This is it. I'll let you read it. I'll shut up. It's very simple. We've got a mixture of lump sums and or quantities times rate. It's up to the client to decide how they want to set up that payment mechanism. So the client can choose to have items with unit quantity and rate. So for example, you might have a contract requiring 100 different bridge assessments, and you might have a price for a big bridge assessment and a price for a little bridge assessment. Obviously, if that was properly defined in the scope, you could just have a simple rate for doing a chunk of work. Or items in the price list can be lump sums, in which case the consultant takes the quantity risk. The consultant's just got to do what it says in the lump sum. If you're doing that, you may want the bidder to actually enter their own lump sum items in the same way as you would do for a construction contract option A. Some of you will know what I'm talking about. In other words, you get the bidder to write out the things they're going to do. At the end of each thing, they're going to get paid the amount that they put in for that item. So we've got a nice, simple payment mechanism. A little bit of a warning, the red again. In the price list, there is a box where you've got to write in the method and rules to compile the price list. So this is a little bit like a method of measurement for a bill of quantities, which will mean something to some of you and not to others of you. Basically, it's just the rules for how we're going to set out how we're going to measure things. And a warning to you as a client, if you make mistakes in your price list, in other words, if you don't follow those rules, it will be a compensation event and the consultant might get some more time and or money. Now, I'm slightly concerned about that, and I'm an NEC nerd, so I wrote an article about it. So that's a 2 or 3 page article. There's a link to it there. It will be in the presentation that comes out to you at the end of this session. Go and have a read of that if you're interested. So when it comes to payment, there is no price for services provided to date. That won't mean anything to you at all unless you know the PSC. If you know the big PSC, that's a term. In the short contract, we don't bother with that. We just go straight to the amount due. And it says the amount due for each lump sum, it's the price for that lump sum which has been completed. Where there is a quantity, it's quantity times rate. And also there is an option for having work carried out on a time charge basis. And as you'd expect, on a time charge basis, we'll pay the consultant based on the time that they've spent doing that bit of work, times the people rate. People rates are in the contract data. And on top of that, the consultant gets a fee percentage. If
Hi,
the client wants... Yeah, please.
Sorry. One question. Martin has asked, can you provide a link to your article on price lists, please?
I can do that. You want me to do that in the call now? You're just thinking I'm a little bit fancy now, aren't you? Okay, you get, for heaven's sake, you are asking a lot. Do you
We
think
can share it post-webinar as well if
Do you
needed.
think I'm some sort of IT wizard or what? Hang on a minute. No. I've asked for questions. I'm going to answer the questions. I happen to have my little spreadsheet of very good articles on the NEC. That's the one that you want. Right-click, copy. Apparently, I can put that in the chat box if I know what I'm doing. But now I'm going to blow it now. How do I find the chat box?
We can do it
Anybody
post-webinar, Richard, if you want to.
I tell you what, let's do it post-webinar. Sorry, I've blown it there. I'll carry on.
No worries. Martin, we'll definitely share it with you. Carry on, Richard.
Okay.
Thank you.
We'll put it on the website as well, I'm sure. So going back to where I was, this is what it says is the amount due. You've got 1, 2, 3, 4, 5 subsets of the amount due, and it all makes sense. It's not hard. The only bit that's a little bit confusing is these last 2 bullet points, other amounts paid, other amounts retained. That just cleverly picks up anywhere in the contract where it talks about the consultant paying or the client retaining. So those are all the headings. As a client, you will go through each of those, add up the numbers, that will be the amount due. Hopefully, as you can see, the amount due is a cumulative amount. As we go through the job, that amount due will gradually grow. And what the contractor actually gets paid is the change in the amount due now compared with what's already been issued. All very simple. But worth mentioning, that is the only reference to time charge basis anywhere in the contract. So clearly, if you do want work on a time charge basis, you've got to be very clear in your scope as to what you want to be done on that time charge basis. This got me thinking, so you've got this slide as well. We've just said that 50.3 allows payment on a time charge basis. And if the guidance notes in the contract actually says the contract does not provide to be paid on a mixture of time charge and prices, one or the other must be selected. I don't believe it. I don't think it has to be, and I checked this with the head of NEC only last week. The way that we wrote that is because the NEC is concerned about consultants, clients not doing it properly. But if you are clear in your scope what is going to be paid for on a time charge basis, if you make it clear that you're going to want timesheets for that, then you're okay. Obviously, the problem you have to be careful of is that if you do have a certain amount of type of work on a certain part of the work on a time charge basis, you've got to be wary of the consultant booking other work to that code and trying to get paid for other stuff. That's just something you're going to have to manage. Hope that's clear.
Hi, Richard. A couple of questions.
Yeah, please.
So we have one from Laura asking, does the consultant have to use the agreed prices in the price list if there is a quotation given as part of a CE?
Okay, we haven't got on to CEs yet. CEs are coming later. Everything I've talked about at the moment is just the basic work that was in the scope when we tendered. We'll come on to compensation events in a little time. Carry on.
Thank you. And one question from Kaylee. If you include 5 days commissioning in the scope and wish to be paid a day rate for additional commissioning, how should this be stated?
Oh, that's difficult. What you would probably have to do is to get the scope change to say that any work over that 5 days was going to be paid on a time charge basis. But you would have to negotiate that in as a change in the scope.
Thank you.
Okay. Thank you. I hope those are clear. So it's a super flexible beast is what we're trying to get to. What does that price list look like? Those are the columns, pretty obvious. But you do have to think about who is actually going to complete the price list. Typically, the client will give out a price list and ask for it to be priced. As I said, sometimes if it's a really open thing, you might actually ask the bidders to put in their own items for pricing. And as I mentioned before, we do have to have this document, the method and rules used to compile the price list. And as mentioned before, if we make a mistake in that, it's going to be a compensation event. Okay, big issue about risk allocation. Now, really simple. Anything that's priced, the efficiency risk is with the consultant. They've given you £100. That's all they're going to get paid. Anything that's got a quantity, the efficiency risk is still with the consultant, but the quantity risk is now with the client. And obviously, I hope, anything on a time charge basis, the efficiency of how efficiently the consultant does the work, that risk is now with the client because the client has offered to pay whatever it costs. When it comes to risk allocation, there's no secondary options. So if you know your PSC, you'll know there is an option for adjustment for inflation. There's an option for adjustment for changes in the law. Those are not in the contract. So as a bidder, you should be concerned about that because that means you're taking the risk of inflation. You're taking the risk of changes in law unless you negotiate something into the contract with your client. Particularly, obviously, the inflation risk. If your short contract is for anything more than 6 months at the moment, I would suggest you probably want to make sure you've got an inflation provision within it. That's not in the short contract. So that's the general ideas about risk allocation. What about specific events? Like any NEC contract, this slide is in all of my NEC training. A compensation event in NEC language is an event which, if it occurs and it wasn't the consultant's fault, it will entitle the consultant to get compensation. It's called compensation. It's a nice word. It's a nice cuddly word. It's friendly, isn't it? The consultant will get compensation, time and cost because this compensation event has happened. So compensation events are very key to risk allocation and management under this contract. What are the compensation events? Well, 8 of them are in clause 60.1. They're all in a nice little list. You might need to add additional ones if you want to change that risk allocation. You might need to delete some of them if you want to. The consultant won't like that. We can also state assumptions in the scope, which is effectively the same as setting up a compensation event if those assumptions are not correct. Unfortunately, there's no space to put additional compensation events in the client's contract data. If you want to add compensation events under the contract, you're going to have to go in and add that in as an additional condition. Having said that, if you did want to just have a nice little box in the contract data for additional compensation events, that would be a very simple additional condition to set that up. So these are the compensation events. I haven't got time to go in all the detail, but it's only those 8 bullets. If any one of those things happen, consultant might get some more time or some more money. By far the most common one is number one, because the client, as you might know, in our world, keeps bloody well changing the scope. Excuse my language. In NEC, there are no claims, there are no variations, there are just compensation events. Okay?
Hi, Richard.
So,
One quick question.
Yeah, please. Yeah.
So if there is a delay on materials due to global shortages and you do not meet the end date, are you as the subcontractor going to have to take on the additional cost to procure the items and then quoted cost from an alternative supplier?
Okay, good question. I'm confused by use of the term subcontractor because we're not talking subcontractor in this presentation at all. We're just talking a client and a consultant is the contract we're talking about. But in principle, the consultant's only going to get extra money if they can find a compensation event. And I can't see anything in that list which says, oh, I've had a supply problem because there's a big problem with shipping in China. It doesn't say that anywhere. And therefore, by definition, in NEC is wonderfully clear cut. If it ain't a compensation event, you ain't going to get any more money. So as a consultant, when you're bidding, you do need to think about the things that you don't want to price for, and you need to go back to your client and get them added in as additional compensation events. Really good question, given the current situations we have around the world at the moment. I've got to push on. So I like this picture. That's what you all do for a living. You take risks out of contracts. When we get the NEC's language for money is the total of the prices. That comes in from the consultant before award. That's the bid number. Anything within that is a consultant's risk. Anything outside of that is a client's risk. And if you've been listening, you'll realize that those clients' risks need to be clearly compensation events. You need to make sure your contract calls them compensation events, because those are the only things for which the consultant can get any more money. Lastly, defined cost, which I put here as part of getting the tender documents together because we'll see the contractor has to tender a number called a fee percentage. So the defined cost is only used for compensation events. There is no other detailed document. The professional services contract, PSSC 4, now has a schedule of cost components. You haven't got one of that in here. It's very simple. Defined cost is just people times people rates, time I should say, times people rates of the consultant's own people. Those people rates are the people rates in italics in the consultant's contract data. So those are the rates that are submitted to the client as part of the bid. So if a compensation event happens, the consultant gets paid at those rates. So typically we have a banded rates. We could have individuals, but normally we'll have a rate for a graduate engineer, senior engineer, whatever. You just need to make sure that those bandings are clear. And if there is any work subcontracted, then the consultant gets paid the defined cost of the subcontracted work. And on top of all those elements, the consultant also gets a fee percentage, which I probably should add to that slide. I'll do that later. Deep breath. That's 35 minutes out of an hour. We've got a contract in place. Is everybody still with me? Have you got any more questions in there?
One's just come through.
Yeah.
For a consultant to get the amount specified in their risk, will this be through a CE?
Okay. You say specified in their risk. That's where I don't understand what you're talking about. If what we were trying to say, if it's a consultant risk, yes, the consultant's going to have to price for that, and they'll have to include for that in their prices. And they're only going to get paid what it says in the contract. Those prices are all they're going to get paid, full stop. If a risk happens, which is a risk that the client specifically wanted to be a compensation event, and therefore that means the consultant does not have to price that risk in the tender submission, if the client has done that and made it clear that that event will be a compensation event, like we talked about a moment ago, problems with supply chain and all that sort of stuff. If you were able to negotiate that in as an additional compensation event, and then that happened, then you would get some more time and money according to the compensation event process, which you're going to hear about very shortly. Okay, so We've done half an hour on putting the contract together. I've now got only half an hour to tell you how to manage this contract. It's a very good job it's short, isn't it? I'm going to use the same structure as the contract for the slides that follow because it's very well structured. Why not? Who's involved? Everything we're talking about is the professional services short contract. It's between a client and a consultant. I've told you before, there's no service manager, but the client can appoint a person called a client's delegate and can tell the consultant which of the powers of the client's delegate is allowed to use. So we can do that to manage the contract. And if we wanted to appoint that person, if you didn't have a client's delegate role person in-house, you might actually use the professional services short contract again just to appoint that person. On the right-hand side, the consultant appointing a subcontractor, oddly it's called subcontractor rather than subconsultant. Don't worry about it, just live with it. And again, you would use the professional services subcontract, maybe with a few little tweaks. I believe in the guide notes to this document, there is some guidance on those tweaks that you might need. The only other person that might be involved, I really hope not, is the adjudicator who would be appointed under the NEC's Dispute Resolution Services contract. So that's just a simple picture showing you who we're talking about. Hope that's clear. In terms of the routine jobs that you've got to do as a client and a consultant to manage this contract, this slide says these are the key ones. And I've intentionally put a few in there with a line drawn through them relating to the differences between the PSC and indeed, actually just a bit careful. It's a little bit wrong, my slide, to be honest, because there is no design acceptance even in the professional services contract. There is no mention in the conditions about the acceptance of anything, any submissions from the consultant. So if you need a process to talk about that, you're going to have to write that in a bespoke document called the scope. In the short contract, there is no requirement for the consultant to ask permission to subcontract. It's just not in there. And therefore, there is no process for subcontractor acceptance. And in the big professional services contract, program is a massive thing. I gave a 3-hour training course on the NEC program only yesterday. In this contract, all it says in the contract is the contractor submits the program as stated in the scope. So if you want one, you're going to have to write in the level of detail that you want in your own way in the scope document. When it comes to payment assessment, compensation events, those are key things that have to have attention dealt with them, and we'll talk about those later on in this session. Now, yeah, please.
So we've had one from Andrew asking, how do you prevent people in a time charge band being promoted to another band? Is there a clause to require a client to approve their promotion in title despite not matching the requirements in the higher band?
Lovely question. There's nothing like that at all in the PSC. In the PSC, all it says is we'll pay people based on the rates. Now, if the rate states graduate and senior and principal, and if an individual is promoted halfway through the job, they will suddenly automatically go up into the higher rated band. So that itself won't be a problem. Having said that, it's a really good question. Fantastic question. Also, for compensation events, the consultant is required to state people rates. And those rates apply to that person full stop. There is no mechanism to get those rates increased if that individual gets promoted. Good question. Really good question. Hope that was a good answer. Any more?
Thank you. One more from Kaylee. As the consultant, if the end contractual date is realigned due to denied site access, can you be charged preliminary costs for keeping the project open from the subcontractors?
Good question. Two things. Firstly, if the problem has been caused by one of those compensation events, then yes, the consultant will get extra time or money. How that extra time or money will be assessed, you'll see if we ever get there when I tell you about compensation events. I'm going to move on. So my favourite slide in any NEC training, and I do an awful lot of this, these are the first two lines in this contract. The parties shall act as stated in this contract. What a lovely, simple phrase. Now, I tell all my friends I don't like CMAs. You know what a CMA is? Probably not. It's a completely meaningless abbreviation or a completely meaningless acronym. But I like to summarize that sentence as that one. And you can have a good guess, but I think you've already cracked it. Do what it says in the chuffing contract. Apologies for the word chuffing if it upsets anybody. The first sentence in the contract says, do what it flipping well says. So everybody on the call, please recognize that. This is not a contract to be put in the drawer. You've got to do what it says. To be able to do what it says, you're going to have to spend some time, my friends. You're going to have to read the chuffing contract. That's very simple, isn't it? Those are the easy bits. The hard bit is number 2, 10.2. The parties act in a spirit of mutual trust and cooperation. What a lovely phrase. What does it mean? I've got no ideas. You can ask the lawyer and you'll get a very long answer. If you ask Richard, you'll get my favourite acronym for the world, TALTIO. Chuffing, talk and listen to each other. Wouldn't it be nice if Mr. Trump and maybe Mr. Johnson were better at a bit of TALTIO? It's good for all of us, and it's how we manage our own relationships in life with our loved ones. And my suggestion to you is if you're going to manage a contract successfully, you've got to do each of these 3 things in this order. Read the contract, work out what's going on, talk to each other, and then do what it says in the contract. Sometimes at this point in a face-to-face course, I just get up and pretend to walk out of the room because you're all intelligent people. You can all read the contract. What more do you need from me? Okay, maybe you do need a bit from me. Communications, very simple. Everything's got to be in writing. But one clause that's missing from the big contract is a clause which says notifications have to be communicated separately. But Richard Patterson's going to tell you it's still good practice to keep all the communications short and sharp and separate. NEC is like this, very, very time-based. You have to reply within the period for reply. The period for reply is in italics, which means it's in the contract data. Typically, it's going to be a couple of weeks. But that period of reply only applies if there's no specific period stated in the conditions of contract. And oddly, in the conditions of contract, there is only one box for the one period for reply. If you want a different period for reply for different types of things, there's nothing to stop you putting in a separate box in the contract data as long as that's clear. Because of all that, you need a system. Now, it's only a short contract. Maybe you don't need a fancy in the cloud system, but you do need to be clear about with your other side how we're going to manage all the stuff that you're going to hear about in the next 20 minutes. Some key clauses. Firstly, if the client accepts something, it don't mean nothing. It doesn't change the consultant's responsibility. The client can delegate, we've mentioned. The client, most important clause, very, very important clause in this contract. The client may give an instruction to change the scope. And now this is the best PowerPoint I've got. Are you ready for this? There you are. That was the client doing what they do all the flipping time. They move the goalposts. That's the problem of our industry, but that's just what happens. And then the contractor's got mechanisms to deal with it. Okay, early warning. Same process as in all the other contracts. There's a requirement to notify an early warning to the other side of anything which could increase the prices. Now, if it's going to increase the prices, as we'll see in a minute, it's going to have to be a compensation event. Or if this problem might delay completion, impair the usefulness, or, quite concerning this one, affect the work of the client or others with whom the client is in contract. Slight concern, that one, because it does mean that the consultant's got to really understand how their work is going to get used, because anything that might affect any of those 4 bullet points, you're required to notify an early warning. It gets simpler. That's all it says. Dramatic pause, because you can read it better than I can. And if you know your NEC, you'll know what's missing. There's no early warning register, There's no formal early warning meeting, but both of them are probably going to be a good idea. One last thing, the early warning process in the short contract has no commercial teeth. Some of you will know that under the big contract, if you don't early warn, there is a slap. There's an effect. I don't need to tell you because it's not in the short contract. So there's no commercial teeth on not providing the early warning, but we obviously hope that both sides will use the early warnings because it's a good for both sides. That's what early warning does. Helps us manage our contract. Anybody out there that's used NEC will know how good early warning is to help us all do our job. Okay, providing the service. Again, I've got to move on. Simple clause we've already mentioned. The consultant provides the service in accordance with the scope. Nice clause for a consultant. Very clear that your liability is for due skill or for skill and care, which is what a consultant will like to see. And as I mentioned before, there are just no words about submissions, design submissions, report submissions, anything. If you need a process for that, you're going to need to say that in your scope. Subcontracting, I've already mentioned. Subcontractor is just not defined term. All it says is if the consultant does subcontract, they're still responsible. And it also in the same clause, it says the consultant uses the key person in the contract data or seeks acceptance of a replacement. So in the contract data, the client can identify specific jobs for which it wants to see the consultant name an individual. That individual might actually be included in your tender evaluation, but once they've named that person, they've got to use that person or ask nicely to get that person replaced. And there's a clause for that in 21.2. Time. Gentlemen, please. As I said, the short contract has very, very limited requirements. All it says is that the consultant says every week they have to tell the client when they think they're going to finish, a forecast of the date of completion. And then this lovely line, the consultant submits programs, whatever it says in the scope, mate. Up to you to decide how much of a program you want to see. Remember, the whole idea of this contract was it's supposed to be for short, simple contracts. It doesn't need the full-blown, heavy program requirements that you will find in the Big Brother professional services contract. Having said that, when you write what you want, you might go and steal some of the things from the PSC. In terms of obligations in time, the obligation is to achieve completion, which is when you've completed the service, except for little defects. One line, consultant doesn't start until the starting date and does the work to achieve completion before the completion date. I've said it 3 times today already on different training courses. NEC would be easier to read if you get in your mind that completion date is really the required completion date. That's when you are required to achieve completion. And then once that completion is achieved, the client decides that date and certifies it. All very straightforward and simple. I will draw you a picture of the dates. We've got a starting date when the consultant has to provide insurances. Completion date in the contract data is when we've signed up, when we promise to achieve completion. But then we have another one, the completion date with capitals, not italics. So the italics is in the contract data in ink, hard-coded, doesn't change. But the completion date, the required date to achieve completion, might change. The most obvious thing it's going to change is by compensation events and possibly by accepting defects. We've also mentioned the consultant's got to give you a forecast date of completion, which will logically be when they think the end of their program is going to be. But remember, there doesn't have to be a program. That's updated weekly. There's also the date of completion, which is when it's actually certified. And then there's a defects date, which is the last date to notify defects. Completion itself is a state, not a date. Anything in italics is in the contract data. That's NEC standard language. And there's no key dates. There's no sections, both of which are in the professional services contract. Short contract, it's very simple. There's a chunk of work, get it done by a date, and I'll certify completion. Hopefully that's clear.
Hi, Richard. One quick question. What
Please?
is a little defect, please?
Did I say a little defect? Sorry, I didn't. That's very naughty on my part. That was back here somewhere. So completion is when the consultant has completed the service in accordance with the scope. Oh, hang on, except for correcting notified defects which don't actually prevent the client from using the service or others from doing their work. So that sentence, if you read it carefully, that effectively creates two different types of defects. Little ones that don't stop completion, and big ones which allow the client to not certify completion. Good question. I skipped over that a little bit too fast. Hope the answer is clear. Okay. So how do we change the completion date? Only by compensation events or by acceptance of a defect. That's when the consultant can say, look, I know you didn't like that bit in the report. I agree it's a defect, but how about you let me off completing it? If so, I promise to bring the prices down a bit and finish a bit earlier. There's a mechanism for doing that in clause 42.1. But by far the most important clause in this session here is that one. A delay to the completion date, remember that's when the contract consultant is required to finish, is assessed as the length of time that, due to the event, completion is forecast to be delayed. That's all it says. There's no rules. There's no reference to a program, because remember, there might not even be a program. So the consultant told you last week when they're forecasting to complete. You've now got a compensation event because the client's asked you to do some more work. You're now going to have to convince the client when is the latest forecast to complete. And that will then be, you will then get that entitlement to move the completion date, the required completion date, to the right. There's nothing for acceleration in the short contract. And advice here to consultants on the call, even though a program is not required, given that you're going to have to try and justify why you think the forecast date of completion is going to be moved, I would strongly recommend that you would keep track of that, and sensibly there will need to be a program in the background at least. That was quality. That was time, sorry. Quality is one very boring slide. NEC has the word defects in all of the NEC contracts. Client can notify defects. This is in the thing being provided by the consultant. At completion, the consultant tells the client, is honest with the client and tells the client anything that has not been corrected. The consultant corrects defects within a time which minimizes the adverse effect on the client. That's all it says. And there is this clause to do a deal to accept defects. Lastly, if the consultant hasn't corrected a notified defect within the time required by the contract, the client can assess the cost of having somebody else step in to correct that defect, and the consultant pays the amount. Let's hope we don't get there too often. Payment, big issue. Two more big issues, payment and compensation events. I hope you're still okay with me where we are. We're getting close to the hour. I hope I'm still okay. We don't have a price for services provided today. As I mentioned, we only have the amount due. Defined cost is only used for compensation events. That's what it says for prices. You've already seen that slide. Price for services provided to date. I think we've already said this, have we not? Lump sum in the price list, we have already said this, so I don't know why. I'm repeating it here because it's in the presentation part about managing the contract. But we've already talked through that slide. This is what the client's going to have to add up each time to work out how much is the amount due now, amount due on a particular assessment day. Very, very simple. As I mentioned, though, the price list includes this method and rules. The method, there's a clause which says the client gives an instruction to correct a mistake in the price list due to either of those two bullet points, including a very wide ambiguity or inconsistency. So if the price list is not consistent with the scope, then there's a need to correct it, and then the consultant gets more money. That's where I think for many clients, they will want to change that mechanism to make it much clearer that the consultant's only going to get paid what it says in the price list. That would need a change to the contract. That's the subject of the article I mentioned before. The routine payment assessment, consultant assesses the amount due and submits an invoice before each assessment day. The assessment day is in italics, typically monthly. If the consultant doesn't bother applying, they don't get any extra money. That's what it says in 50.4. Very simple. The client can correct the amount due. The client can apply delay damages if the consultant's late. And that's it. That was payment. That was horribly simple, was it not? Have you got any questions for me on that then? Very simple, I like to think. Which sets me up for the last but important bit is compensation events. Where are they? They're in 60.1. They might be in your additional conditions, and they might be effectively compensations being set up by assumptions in the scope. Again, no claims, no variations. That's what they are again. You've seen them already. I'm not going to go through them in detail. We have this lovely term assumptions. This is worth a little bit of a talk. I explain it on this slide. Once we've agreed a compensation event based on a forecast of cost, we don't come back and revisit it. The deal was done, get on with it. 63.7 says the assessment can include risk allowances for things which might happen. So the consultant then has got to include for a whole load of possible risks. So the client might say, well, I've got to include for the risk that I don't get something from the planning authority by Thursday. That's going to add to the prices. It's going to add to the time for this compensation event because the consultant's including for risk. What we can do, though, we can state an assumption. So we could say in the quotation for the compensation event, we could write in, it's assumed that the consultant gets the information required by Friday. And the quotation is built based on that assumption. What's different in the short contract is that either the consultant or the client can state assumptions. In the big contract, it's only the service manager that can state the assumptions. And also different, if those assumptions prove to be incorrect, either party can notify assumption, notify a correction, and that correction itself triggers a new compensation event. It's a really subtle, very important part in all NEC contracts. It just gives the parties the opportunity to do deals, basically, by taking risk out of quotations by carefully worded assumptions. To make that work, though, Taltio, talk to each other. Have a chat about what assumptions are appropriate so that when the quotation comes through, you're happy as a client to accept it. In terms of the money, the short contract is different from the big one with this clause. If this compensation event only affects the quantities, then the change to prices is worked out by just multiplying the change quantities. But very often the consultant will say, well, it doesn't only affect the quantities. Therefore, we go into the standard clause, standard for NEC, we'll assess the compensation event based on the actual defined cost of work done, the forecast defined cost of work not yet done. And I underline the word forecast because normally at this point I shout the word forecast because it's so important in an NEC contract. This is what makes NEC different. We don't just sit back and work out to come back later with saying, well, this is how much it cost me, this change. We have to sit down and forecast it. Really, really important. Compared with a big contract, there's no dividing date, but logically the dividing date, in other words, the date between the actual and the forecast will be the date of the notification of the compensation event. There's also a clause which says if you want to, you can just agree some rates or lump sums from anywhere to assess the change. You can just do a deal, basically. And that's it. That's money in the short contract. I'm lying. There's another slide. The effects of the compensation events, we calculate defined cost. Defined cost is based on rates and percentages in the contract data. Anything else, like, for example, subcontractor inputs, are open market or competitively tendered rates. And also a nice easy clause, if the people rates don't include a rate for a category of a person required for this particular compensation event, nice easy clause, client and consultant may agree a new rate. If they can't agree it, the client dictates it. Very simple. In terms of the time, we've already talked about it. Delay to the completion date is based on the length of time that because of this compensation event, completion is forecast to be delayed. No rules, no reference to program. Contract also has a clause 63.7 which says the contractor can include risk, and it also says that the consultant is assumed to react competently. You'll be glad to know. As before, if there's ambiguity, the consultant will win. Lastly, if there is a compensation event, we'll need to change the price list because the consultant, if we add in an extra chunk of work, we've got to show how the consultant is going to get paid for that extra chunk of work. That's going to need a new item in the price list. And as I mentioned before, if and when that compensation event quotation is accepted, or if the client steps in and makes the assessment, then the compensation event is not revised. It says not revised except as stated, and the only place where it talks about possibly revising it is in the dispute resolution process, which we're not going to talk about today. I like pictures, so let me show you all of that on a picture. As an example, the client changes the scope. You need a 14.2 to change the scope. You then need to notify you've just called the compensation event because you've just changed the scope. That compensation event, you'll tell the client, which event it is, and the client will say to the consultant that was a 60.11 because I've just changed the scope, and at the same time you instruct a quotation. Having said that, if you think the change arises from a fault of the contractor, you'll say so because the consultant's not going to get any money. Sorry, I keep flipping between consultant and contractor. We're talking about consultant here. The consultant's got only 1 week to put together a quotation. In doing that, they're going to have to take into account all of those clauses, all of which we talked about. Sorry, I haven't got time to talk about them again. Quotation comes in. The client then has got only 2 weeks to reply. You've got 4 reasons in 62 to say nothing. If you don't say nothing, you accept. And if you don't accept, there is no clause to ask for a revision. If you don't accept, the only option is to step in and make your own assessment, tell the consultant the answer, and that's it. And if you've done that, the only way for the consultant to challenge you is to take you up to dispute resolution. And in the short contract, that means straight to adjudication. So I hope you can see from all of that, you need to talk to each other. You need to build up quotations together so you're happy with the quotation when it gets formally submitted. That's true in any NEC contract. On the other hand, if it's a late response from the client, which is a compensation event, that's going to be notified by the consultant. Important clients, consultants, particularly consultants on the call, you have to notify a compensation event within 4 weeks. Otherwise, you get what is contractually called diddly squat, nothing. Within 4 weeks, you notify, you tell the client which event you think it is, and this is where it's different. You submit a quotation at the same time. That quotation comes in, and therefore, on my nice little picture, effectively we jump straight to that stage, and the client has to review it in the same way as they reviewed a quotation come on the left-hand side. Hopefully that's simple, but there's a little bit more complexity. If we don't get a consultant within the time allowed, the client steps in and tells the consultant how much they're going to get. NEC is all about getting things sorted in seriously short time periods. More of a concern for a client, if you don't respond at all within the 2 weeks, then the compensation event quotation is treated as accepted. That's a big one for clients to take. You need to make sure you've got resources to manage and to check and review these quotations that are coming at you. Hopefully that's a good slide. That's a really good summary slide of how the compensation event process works in the short contract. Little slide here. As you go through the job, you're going to keep a record of what we've actually paid out and where we've got to with the compensation events. That suggests on the orange line that we know where we are with all the compensation events. In the real world, we don't. And at each point, there's a big gap. There's a big range of possibilities depending on what we actually end up agreeing for these compensation events. So all the way through the project, as that box will always get bigger and bigger and bigger, client and consultant have got to get their heads together and do some deals so that we don't end up with a bun fight at the end of the contract. These processes are all separate. Change to scope might lead to a compensation event. An early warning might lead to a change to scope. An early warning might precede a compensation event. A change of scope might also have to be showed on a program if there is one. The program compensation events are also going to be shown on the program. The program, it doesn't say it specifically, but obviously it will be helpful in assessing a compensation event. And once we assess the compensation event, if there's a delay to the completion date, that delay to the completion date will be shown on the next program. Rushing a bit now, as you can hear, but hopefully that's a useful slide just to summarize the way that these various processes interrelate with each other. I think I'm probably going to leave it there. I'm up to over an hour. I've got a couple of slides on liabilities. Shall I do it? Maybe I'll finish it, sorry. So rights to material, everything needs to be stated in the scope, as we've talked about. Right to use the material, rights to use the material for somebody else, and so on. So you need, when you're writing the scope, to take this very seriously. And when it comes to liabilities insurances, firstly, client liabilities, a little bit odd to my mind. These are not compensation events. In the professional services contract, they are. As a consultant, personally, I would try and get that changed. Consultant liabilities, that's what it says in the contract. Claims and proceedings from the client and others, and compensation and cost payable. This is what the consultant is liable to, but only due to a failure to use due skill and care, which most consultants will be happy with. I'll be honest, I was looking at this contract with my people in Mott MacDonald only last night, and we have a little bit of a concern over the word others there in this liability clause. Recovery costs is nice and clear. Proportionate liability is in there as well, and there's a clear clause requiring the consultant to provide insurance. Limitation on liability is a very, very key thing for consultants. We're always going to be looking in there carefully. And in the contract data, the client's contract data, it says the consultant's total liability to the client, which arises in the contract, is limited to the amount stated in the contract data. Well enough, there's only one amount. And my concern from a consultant's perspective is it doesn't mention that liability to others. So that's one for your lawyers as a consultant's people, your lawyers to have a look at and see whether you think you need a change there. Termination resolving disputes. The whole process, particularly the compensation event process, is all about avoiding disputes. If you do get there, either termination or disputes, get the lawyer in. I'm sorry, you're going to need them. The process, though, is very simple. Sort it out. If you can't sort it out, call in the adjudicator. They've got 4 weeks from receiving information from both sides to come up with a decision. If either side doesn't like the adjudicator's decision, we go off to what the contract calls the tribunal. The tribunal is in italics, which means it's a contract data entry. In the contract data, the client will state either arbitration or the courts. And there's another little clause in there if the Housing Grants Act applies. Unfortunately, we haven't got this concept of senior representatives, which is what we have in the big contract. But to be honest, one would hope that the client and the consultant, before running off to adjudication, which will cost a fortune, one would hope that the client and the consultant will try and sit down and do a deal. Deep breath. 1 hour and 10. I apologise for the extra 10 minutes. I hope that hasn't been too much of a pain for you. If it was a pain, you will have gone long ago, and I will never know. Listen, guys, I hope that was of some use to some of you. That's a very, very high-speed run through a very short contract. I don't know whether you've got any more questions in. There's still an opportunity if anybody wants to ask more questions, please do so. Ellie, we've got any more questions in, or has everybody gone off and gone home now?
So what I'm going to do is I'm going to download the questions post-event and I'll send them over to you, Richard, if you wouldn't mind popping some answers to them, and we can put them up in the post-event news story.
I will very, very happily do that. And then if people will come back, I don't know whether you post that and or you email that. Hopefully you can email that out also to all these people.
Yeah, absolutely. Along with the presentation, it will all be available.
Yeah, presentation available. What I'll also send through to you, Ellie, is that paper that or that little article we talked about, so you can wrap that up and also in the output. So at the end of this session, we'll have a nice little pod of hopefully useful information for anybody wanting to use the NEC Professional Services short contract.
Great. Thank you so much, Richard. And thank you everyone for joining us this evening. We'd be grateful if you could complete the post-event survey and also check out our upcoming events and webinars. But thank you again for joining us, and keep well, everyone. Enjoy the sunshine and have a lovely evening. Take care. Bye-bye.
Thank you all. Bye now.